Before we begin, I just want to make a few remarks about the center. Those of you who are students here will just have to suffer through my little explanation. Many of you have not been here before, and I just want to tell you what we do very briefly. First of all, I'm Françoise Meltzer. I'm the academic director of the center here this year. Normally, I'm on the faculty at the University of Chicago. As I repeat, many of you know, the center here has four main functions. The first is that it is for undergraduates at the university to come and take courses in a different environment. In other words, they take the same course, as you know, many of you, in intense form that they would be taking on campus, except they're in Paris. We usually get about 75 undergraduates per quarter. This quarter we have students in the European civilization sequence, in the social sciences, and in neurobiology. And those of you who don't know, the center should know that you don't have to be in French or even wanting to learn French, although you do have to take some French courses when you're here. We also have year-long students who take courses not only here, but also at other universities with whom we have made arrangements in Paris. Secondly, we have graduate students here who are working on their dissertations and who have offices. For those students, we have a seminar, which is where they present the work that they're doing. And that seminar I run, we have about 8 to 10 in that seminar at the moment. Thirdly, we have lectures and conferences here. And finally, it's a place for the alumni of the university who are in Paris to meet and to hear lectures by distinguished alumni, such as we will be having this evening. The center opened its doors here in 2003, so we're coming up on our 10th year. And let me just say a few other things briefly. We have among us here today not only several of you who are alumni, and not only some who are faculty, and not only our students here at the center this quarter, but we also have students from universities with whom we've partnered in Paris. We have two from the Université Pierre et Marie Curie who are going to be exchange students at Chicago next year. We have one from Sciences Po who's also going to be at Chicago next year. We have 7 from the Télécom Paris, which is an engineering school here in the 13th arrondissement near the Cité Universitaire, and which participates in a buddy program for our students. So we have a great mixture. I also want to announce that next week there's going to be a conference on repeat offenders organized by my colleague Bernard Harcourt in the law school in collaboration with the Université Paris-Ouest Nanterre, La Défense. And there's also going to be an international conference on March 15th and 16th on Valère Novarina, the painter, writer, playwright. And that conference is going to be in collaboration with the Paris 8 and the Sorbonne. That's an example of the international scientific collaboration that the center here is undertaking. So that gives you a very brief thumbnail sketch. And now I will give you Catherine Huntington, who's a third-year student in college, here this quarter in social sciences, and I'm going to introduce our speaker this evening. Thanks, Catherine.
Hi guys. It is a great pleasure and honor to have our illustrious alumnus, Professor Elliot Feldman, with us tonight. Professor Feldman was an undergraduate at the University of Chicago between 1965 and 1969. After completing his bachelor's degree in public affairs, he moved to Massachusetts, where he got his PhD at MIT in 1972. In 1988, he received his JD from Harvard Law School, and since 2001, he's been a senior partner and national leader for international trade at Baker Hostetler. He is involved in all forms of trade remedies affecting the movements of goods and services across international borders. He advises foreign governments, international organizations, American and foreign corporations, and individuals on matters of trade policy and international law. Professor Feldman is not only a renowned lawyer in his own field, he is also very much involved in the academic world. He has taught at Johns Hopkins University School of Advanced International Studies, the University of British Columbia, Brandeis, and Tufts Universities. He is the author of 8 books and numerous articles in professional journals and anthologies. Recent articles have appeared in the Financial Times and pardon my French, politique américaine, to name just two examples. Professor Feldman is not only an alumnus of the University of Chicago, but also a friend of the center here. He has been involved with the center since its opening 8 years ago, and came to Paris for the center's 5th anniversary celebration. We are happy that he is back at the center tonight to give the distinguished alumni lecture, the title of which is International Trade and Foreign Policy. Please join me in giving a warm welcome to Professor Feldman.
Well, thank you very much. A very generous and extensive introduction. I'll apologize at the outset that my slides are a little incomplete. I had two very large cases in the month of January, and I didn't have time to do this properly, but I'll do the best I can. So the first slide should have been what I'll tell you now, which is essentially an outline of what I'm going to talk about. There is a mutual commitment between the People's Republic of China and the United States to move toward green technologies. That mutual commitment was confirmed in the meeting of President Hu Jintao and Barack Obama in November 2009. They entered a series of specific agreements for the purpose of encouraging the expansion of green technologies and the placement of limitations on carbon footprints. The specific targets for these policies were solar, wind, and automobiles. Both countries pledged to spend a lot of money for this purpose, and both undertook to do exactly that. Both do spend a lot of money on solar, wind, and automobiles, specifically the development of an electric car, and therefore appropriate battery technology. The problem with this mutual commitment is that it is contrary to the trade law, because trade laws don't permit spending money on anything that's going to be sold, not spending money by a government on anything that's going to be sold to another country. If you're going to sell the product abroad, it's going to be subject to what are called countervailing duties, duties that are fashioned for the purpose of offsetting the value of the money given in the form of a subsidy to the development of a product or the sale of the product. So the essential rule in trade law is that subsidized products, if subsidized for the purpose of developing the product or selling the product, cannot be sold abroad without confronting a countervailing duty. The United States regularly invokes this trade law and has been essentially the teacher to the rest of the world about how to use trade laws, so that now they're invoked more often by China and India than they are by the United States. They've learned very well from us. Nevertheless, they're invoked with great frequency, and in particular, you probably heard more of anti-dumping, but anti-dumping is not a government activity. Anti-dumping is a corporate activity. Anti-dumping refers to the price. It's a corporate decision to sell a product at what's called less than its fair value. Less than its fair value means that it's sold for less than it costs to make, or it's sold abroad for less than you sell it at home. Either one of those functions we call dumping. Now, when you have a sale of a product at home, that's called a sale. You may well sell it below what it costs. You get rid of the surplus. You have a year-end sale. You need to get rid of inventory. All that's just fine. That's legal. But if you take the same product and sell it in another country, that's dumping. That's not fine. That violates the rules of the World Trade Organization. But dumping is a function of setting the price, and setting the price is a determination made by a corporation. Subsidies are a function of governments. And personally, I've spent most of my 25 years now practicing law representing foreign governments. So I've been immersed in particular in the subject matter of countervailing duties and what are considered to be illegal subsidies. We've now begun a cycle since 2009, 2010, since the mutual commitment entered by Presidents Hu Jintao and Obama, of retaliation. The United States invokes the trade law, and China invokes the trade law, and I'll go through some of these examples for you. All revolving around solar, wind, and electric cars. So that the development of green technologies the objective upon which the two presidents agreed has been seriously stymied, and the situation is getting much worse. In part, I assign some of this difficulty to the President of the United States, whom I don't believe understands trade law at all, and who has no advisors and has had no advisors since he became president who are really expert in trade. So although he has articulated an interest in free trade, he doesn't really understand how it works. And the consequence is that the policies and processes of our government run counter to his policies, to his own objectives. As he enforces the trade law, he actually countermands his own objectives in the development of green technologies and in the reduction of the carbon footprint. So that even though these are among the most visible elements which he has experienced in the presidential campaign, think Solyndra, or the A123 battery company in Massachusetts that was just bought by the Chinese after receiving $129 million in subsidies from the United States. Or in the case that I've just been doing, which I'll discuss a little bit later, involving wind power, wind towers, which I've been representing Siemens Energy and wind power. So let's turn first to what the President promised. Now I'm going to hope that these work correctly. Excellent. So this is all that the President said, but this is what he said on the 20th of January 2009 in his first inaugural address, all he had to say on this subject. We will harness the sun and the winds and the soil to fuel our cars and run our factories. That was his pledge, and that's what he then pursued the following November when he met with President Eisenhower. More recently, we've had a much more robust commitment to these objectives. So this is what the President just said in his inaugural address a week or so ago. We'll respond to the threat of climate change, knowing that the failure to do so would betray our children and future generations. And the understanding is that solar, wind, electric cars, those are the three principal elements for dealing with climate change. Some may still deny the overwhelming judgment of science, but none can avoid the devastating impact of raging fires, crippling drought, and more powerful storms. The path towards sustainable energy sources will be long and sometimes difficult, but America cannot resist this transition. We must lead it. But in fact, in our trade law, we resist it mightily, and we don't lead at all. We cannot cede to other nations the technology that will power new jobs and new industries. Here's where the problem begins to develop. Because the essence of these trade laws, of countervailing duties and of anti-dumping, are protectionist. Their purpose is to guarantee that the new technologies and new products are developed at home and create jobs at home. So the President's vision of this has always been to develop export technology, to develop products that we can sell abroad, but without lowering the barriers for them to be sold to us. We cannot cede to other nations the technology that will power new jobs and new industries. We must claim its promise. That's how we will maintain our economic vitality and our national treasure, our forests and waterways, our croplands and snow-capped peaks. That is how we will preserve our planet, commanded to our care by God. That's what will lend meaning to the creed God has once declared. A very grand and grandiloquent statement, and for which he got quite a lot of credit and attention. In the inaugural address, you will probably hear, we were in Washington, and in Washington, this passage from the inaugural address got a lot of attention. So the President created a specific program for the purpose of promoting this technology. It's a collaboration of the Departments of Commerce, Energy, State, Agriculture, the Office of the United States Trade Representative, OPIC, the Export-Import Bank, the U.S. Trade and Development Agency, and their purpose is to recommit the U.S. government to addressing trade barriers in the sector. But by trade barriers, this only meant trade barriers of other countries blocking exports of the United States to them. It did not concern trade barriers in the United States blocking imports into the United States of products from other countries. Part of the agreement in November 2009 was a memorandum of understanding to enhance cooperation on climate change, energy, and environment between the United States and the People's Republic of China. And here's the essence of that agreement. The government of the United States of America and the government of the People's Republic of China, hereinafter referred to as the participants, recognize the following: climate change, clean and efficient energy and environmental protection among the greatest challenges facing the United States and China. Cooperation between the United States and China is critical to enhancing energy security, combating climate change, and protecting the environment and natural resources through pollution control and other measures. Cooperation on climate change, clean and efficient energy, and environmental protection can serve as a pillar of the bilateral relationship, build mutual trust and respect, and lay the foundation for constructive engagement between the United States and China for years to come, while also contributing to multilateral cooperation. Doesn't sound like a trade war, does it? But it spawned a trade war. So in this cooperation, the purpose was for both countries to commit to respond vigorously to the challenges of energy security, climate change, and environmental protection through ambitious domestic action and international cooperation. Both countries resolved to pursue areas of cooperation where joint expertise, resources, research capacity, and combined market size can accelerate progress toward mutual goals. These include, but are not limited to, energy conservation and energy efficiency, renewable energy, combating climate change, and promoting low-carbon economic growth. This is all November 2009. And implementation was to be in climate change policy dialogue and cooperation. Participants concur that their climate change policy dialogue and cooperation should promote practical solutions for promoting the transition to low-carbon economies. I'm emphasizing and reading every word of these passages from this international agreement because it's important to appreciate the difference between an international agreement and the reality in the conduct of public policy, and what happens in the conduct of public policy in trumping the declared and lofty objectives of mutual international cooperation. So in this objective, we've had, in fact, centuries of subsidizing hydrocarbons. We do this in lots of different ways, but the outcome is that the Environmental Law Institute says that in the period 2002 to 2008, we subsidized in the United States approximately $72 billion in fossil fuels and $29 billion in renewable energy. And we do this in lots of different ways in the United States, but our favorite form of subsidy in the United States is through the tax code. So we make tax adjustments, we give tax credits. These are not the most obvious and easily discovered subsidies, but they're discernible if you can make your way through the tax code. And fossil fuels, I'm talking mostly about carbon, oil, gas, have been enormous beneficiaries. This has given them great advantage. For example, there's always been a depreciation allowance for drilling oil. We've always subsidized research and development in oil and gas. And right now, as the United States is about to become energy independent through shale oil and gas, it is the product of substantial subsidies in the research and development for fracking, for the extraction of oil and gas all across the continent. So we have, at the same time that there's great complaint about visible subsidies to the development of wind and solar and batteries, we in fact continue to subsidize at a pace the development of fossil fuels. The IEA estimates that in 2010 alone, fossil fuels were the beneficiaries of $409 billion in subsidies of one kind or another. Renewable energy, $66 billion. The objective then in developing new energies, and the reason that continuous subsidies to fossil fuels create such a problem, is that one has to develop what's called grid parity. Grid parity refers to the competitiveness of different sources of energy in uploading to a grid for the supply of electricity. You have to understand the chain as beginning with a public utility. Public utility is going to buy electricity. It's going to buy the electricity at competitive rates from whatever the source, whether it comes from a coal-fired plant or whether it comes from shale gas or whether it comes from wind power. 29 states in the United States now have established standards that require utilities to buy some portion of their electricity from solar facilities or from wind facilities. But when solar and wind are not competitive, when it costs too much to upload to the grid, the utilities petition and they seek out a lower price, because in the end the public does not want to subsidize themselves directly paying a higher price for their electricity or their heat. So for solar to sell to a public utility, it has to have a competitive price when it's uploaded to the grid. And therefore it has to achieve grid parity, and that's achievable only through subsidies at present. There are areas where there's enough wind so that you can upload, but it's not always windy, and you need something complementary. Natural gas has now become a serious competitor, and indeed is suppressing the development of renewable energy sources because it's becoming so cheap. So as natural gas is making the United States energy independent, it's also driving down the cost for your electricity, but it's driving up the competitive cost of wind and solar. If wind and solar can't find a way to drive their own costs down, they can't compete for grid parity, and they won't be sold to utilities. Therefore, it is in the interest of the public policy to develop solar and wind power as inexpensively as possible. And put that in a simple framework. Inexpensively as possible means what's good for the consumer. Subsidies and dumping are good for consumers. They are protectionist policies because they protect jobs at home. But if you can buy a product from some other country for less than you can make it at home, that may be unfair competition to your domestic manufacturer, but it's a boon to consumers. If the Chinese government chooses to pour money into the development of wind power, it means that those elements of wind power exported to the United States will be cheaper for American consumers, and therefore can accelerate, you remember some of the words of the international agreement, will accelerate progress toward the development of wind power. This is equally true of solar power or batteries for electric cars. Therefore, there is necessarily a conflict between the cheaper product coming from abroad, whether subsidized or dumped, sold at less than fair value, that's the magic phrase, sold at less than fair value meaning sold at less than it costs to make, sold at less than it sells at home, or subsidized by a government, and that less than fair value product comes into the United States, saves consumer money, but it's going to be blocked by the trade laws, because the purpose of the trade law is to keep out products that are being subsidized or dumped as they come into the U.S. market. So for solar and wind and electric cars to catch up with the fossil fuels, they need subsidies. They won't catch up otherwise. There's been huge progress made. Solar power and wind power have dropped in cost drastically in the last 5 to 10 years. Nevertheless, in most areas, they're not competitive unless they're subsidized. In the United States, there's an area that I call the wind corridor, some people call Tornado Alley. It runs roughly from the Dakotas down through the middle of the country, through Oklahoma into Texas. That's the windiest part of the country. And that's where most of the wind farms are being built. In some areas of that wind corridor, wind power is competitive with natural gas being the key competitor now because of shale. But in most areas it's not. And in most other parts of the country it's not. So the only way that wind power can in fact capture a larger part of that upload to the grid is through subsidies from the government. Exactly what the trade law forbids. So I'm going to digress for just a moment. I was kindly introduced as having some association with the Paris Center, but I'm going to digress for a moment and talk about that a little bit. you're all very fortunate to be able to study here and in other centers around the world. The University of Chicago didn't always believe in foreign study. When I came to Paris in 1968, I did so against the rules of the university and the wishes of the dean. The university did not recognize any study that took place outside of the University of Chicago classroom. And the French language was taught strictly as a language to read. It was taught for literature. It wasn't taught to be spoken or to understand what you hear. That tradition dated from the 1930s. It wasn't uncommon in universities. Great literature, scientific literature, was often considered to be in foreign languages, and you learned the foreign languages for the purpose of being able to read that literature or read that science. My mother was a chemist. She studied at Harvard in the she was in the class of 1929. She learned German strictly to read the scientific literature. She never learned to speak any or to hear any. But in the 1960s, the University of Chicago was still teaching languages that way. So if you wanted to learn to speak it or to hear it, you needed to study it somewhere else. I did. I took a summer. I took the first year course at Harvard in a condensed 8-week summer program. It was 5 hours a day, 5 days a week. And when I finished, I received no credit from the University of Chicago because it was not a recognized course. And then I came to Paris by hitching my wagon to a University of Chicago professor who was coming to Paris on a Guggenheim Fellowship. We had a deal. I was registered at the university in Chicago for reading courses with him in Paris. And I was registered for reading courses in Chicago with a couple of other faculty members. Gerhard Casper, who had just arrived at the university, agreed to take me on. Ari Zolberg took me on, and I came here with Theodore Lowy when he was writing The End of Liberalism. So I was, as far as the university was concerned, still in Chicago. I was paying tuition in Chicago. My courses were all recorded as Chicago courses. I never attended a course in Paris. And I did my research for my bachelor's thesis here, working with Professor Lowy. Now, I go into that digression just to give you some sense of what, and I believe I was therefore the first student in the history of the university to study in Paris and get credit for it. But I digress in part because I want to introduce you to a basic rule I learned as an undergraduate from Professor Lowy. Professor Lowy taught a course, a very famous course in those days, on the politics of public policy. And his first lesson was that if you want to understand public policy, you have to begin with the statute. This was a very strange message to undergraduates who don't study law and don't think of public policy in those terms. But the message was, if you want to understand public policy, start with the statute, and I'm going to start with 2 statutes now in order to try to explain to you how the trade law trumps all of the things I've just been describing in terms of our policies and objectives in renewable energy. We have 2 sets of laws that are concerned here. The first is the one that may be more familiar to you in some respects, or at least you've heard of it, which is the WTO, the World Trade Organization. It's, in theory, international law. I say in theory because it's not formally enforceable. The way the WTO decisions work is that if you win at the WTO, what you win is a right to retaliate. You win a right to have your rights enforced only through what's called compensation for a derogation of your trade rights. The rule itself, in terms of the decision of a WTO panel, is not enforceable. So if you're on the losing side of a WTO proceeding, no one can make you do anything. What the WTO does is authorize the winner to take compensation from you. So the WTO rulings are only prospective. It doesn't punish you for any past misdeeds. And one of the objectives of parties in WTO proceedings is to stall for as long as possible, because with only a prospective ruling, the longer it takes to get a decision, the longer you can continue to do whatever you were doing that was wrong. Nothing can stop you until there's a decision, and even then, you can conform only through the pressure of retaliation. The WTO is very limited. It's often misunderstood. Nevertheless, the Chinese in particular believe fervently in it, and they much prefer to take their complaints about trade disputes to the WTO than to subject themselves to the judicial proceedings of any other member country. So the WTO defines a subsidy. And before the WTO came into being in 1994, subsidy was not defined in international trade law. It was a term that was broadly understood, but it had no formal definition. The predecessor to the WTO was the GATT, the General Agreement on Tariffs and Trade, which dated back from 1947. The GATT also formed panels, also adjudicated, but a member could block the decision so that if you lost a GATT panel, that decision might never be published. It might never appear anywhere, because the country on the losing side could say, we don't recognize it, we don't believe in it, and we don't want it to appear anywhere. And they were completely unenforceable. One of the changes that occurred in the development of the WTO in 1994 was that everything is public, everything is published. It's the organic law which is then interpreted and implemented into the domestic law of all the member states, and it began to give definitions to some things like subsidy. So, definition of a subsidy. We're reading from Article 1 of the Agreement on Subsidies and Countervailing Measures. For the purposes of this agreement, a subsidy shall be deemed to exist if there's a financial contribution by a government or any public body within the territory of a member, where a government practice involves a direct transfer of funds, potential direct transfers of funds or liabilities, government revenue that is otherwise due is foregone or not collected, like a tax credit. Government provides goods or services other than general infrastructure or purchases goods. That means that if the government, example is of the largest trade dispute in the history of the world between Canada and the United States over softwood lumber, the structural material that builds houses. I've been one of the lead counsel in that dispute for 20 years. In Canada, the forests belong to the provincial governments because all natural resources belong to the provincial governments under the Constitution of Canada. So the sale of trees is not technically the sale of trees, it's the sale of the right to cut the trees because the trees belong to the government. And the government sells the right to cut the trees. The United States has insisted for the last 30 years that every sale is a government subsidy, that it's being sold at less than the value that it should be sold because it's designed to guarantee jobs in forestry to Canadians. So the United States position is and has always been that Canadian forestry is a subsidy. It's the sale of a good or a service by the government to a private party, and in that sale the price is below the market value. The same is true if a government utility underprices electricity or underprices gas or oil. Anything that the government owns or controls also is an input to making another product. The government owns it and sells it. If the government doesn't sell it at what another party regards as a fair market price, it's a subsidy. A government makes payments for a funding mechanism or entrusts or directs. Entrust or directs is a very formal technical term which I won't discuss with you unless you want, but it's now a term of great dispute among international trade lawyers. Entrusts or directs a private body to carry out one or more of the type of functions illustrated. This passage is written for the purpose of capturing the role of private parties acting apparently in the place of governments, above which would normally be vested in the government, and the practice in no real sense differs from practices normally followed by government. So if a private party is acting on behalf of the government, is doing something that wouldn't normally be the function of the government, it too may be functioning to confer a subsidy. Or there is any form of income or price support, and this comes back to the GATT, we'll go into it, and benefit is thereby conferred. There must be a benefit in order for it to be legally a subsidy. A subsidy as defined in this paragraph shall be subject to the provisions of Part 2 or shall be subject to provisions of Part 3, all of which means it's subject to being countervailable. Now that's the organic law, that's the basis of the implementation of the trade law in all of the member states of the WTO. Each one implements this provision its own way. Each one adapts it to some degree. As a consequence, for example, U.S. law does not mimic exactly the WTO, and in fact, the United States adjusts its international agreements whenever Congress implements them. But this is the U.S. version of the law. So this appears in 19 U.S.C. section 1677, 5, countervailable subsidy. This is the law as implementing the law from the WTO after 1994. Before 1994, there was no definition of subsidy in U.S. law. To be countervailable, a subsidy means that it has to be subject to a counteraction in which you can impose a duty to offset the value of the subsidy. Not all subsidies are countervailable. For example, if we build roads and they're generally used, that's a subsidy. The government will put in the money, but it's not a countervailable subsidy because a subsidy also has to be specific to an industry or an enterprise or a group of industries or enterprises in order to be countervailable. So there's a limitation on what makes a subsidy countervailable. So a countervailable subsidy is described, provides a financial contribution. You saw exactly the same language in the WTO. Provides any form of income or price support within the meaning of the GATT article, just as you saw in the WTO. Makes a payment to a funding mechanism to provide a financial contribution, or entrusts or directs, same language, a private entity to make a financial contribution. If providing the contribution would normally be vested in the government, and the practice does not differ in substance from practice normally followed by governments, to a person the benefit is thereby conferred. Now, you can study this later, because you will see that there are differences between the U.S. law and the WTO, notwithstanding that the language is very similar. Point is that this is the law that's being enforced and is the source of the problem which I've been describing. So a countervailing duty is what follows after you've identified a countervailable subsidy. This, therefore, is in another provision of the law. A countervailing duty proceeding shall be initiated whenever an interested party described in these paragraphs files a petition with the administering authority on behalf of an industry which alleges the elements necessary for the imposition of the duty imposed by Section 1671A. I give you this passage because this is the critical passage for understanding why the President doesn't control trade policy and the problem he has. Shall, in law, means it has to happen. It's mandatory. So a countervailing duty proceeding, which means an investigation, shall be initiated whenever an interested party files a petition with the administering authority, that's the Department of Commerce, on behalf of an industry which the petitioning party identifies as to what the industry is, which alleges the elements and satisfies essentially a checkoff list. The consequence of that provision is that when an industry, self-identified, files a petition and satisfies the requirements of the petition, an investigation must take place. The Chinese have had a very hard time understanding this because in the Chinese law, there's a public policy provision for an exception. It's a public interest exception. The Chinese government can evaluate a petition and can decide not to initiate. It can decide that it's not in the public interest to do so. An example. 3 years ago, maybe 4 now, the Chinese government was presented with a petition by an industry in China for countervailing duties and anti-dumping duties against pulp from Canada and the United States and Brazil. There was a nascent industry in China which wanted to develop pulp for the paper industry, but China does not have a lot of trees, and therefore China does not have access to and the likelihood of a lot of pulp. The government decided that it was more important to preserve the paper industry, which needed foreign pulp, than to assist a nascent domestic industry for the development of pulp. and it rejected the petition. But this week, it hasn't happened yet, but will happen in the next day or two, the Chinese government will initiate on that petition. And it will begin an investigation of countervailing duties against China, against the United States, Canada, and Brazil over pulp for reasons that have not yet been exposed. But the Chinese government has the option to initiate or not initiate an investigation. The U.S. government does not have that option. So when an industry identifies itself, presents its petition, meets the checklist, the Department of Commerce must initiate an investigation as to whether the product coming into the United States is being dumped or subsidized. Because the President has no discretion, because the statute as passed by Congress says that there shall be an investigation, these become issues of international disagreement over and over again. There's a similar problem, by the way, in Europe. The European law doesn't have a public interest exception either. So when petitions are presented, there are investigations. The Chinese will say, why are you doing this? We agreed that we want to develop solar power and wind power. We agreed we want to develop electric cars. Why are you objecting that we invested a lot of money in developing these things and we're now selling some of it to you? And the first line of answer is in the statute. The President has no choice. He has to permit the investigation to go forward. And countervailing duties will be imposed if the investigation leads in that direction. So let's talk a little bit about some of these cases and what's happened. I've been writing about this for a while now, and so I can refer you to our blog, which is called the China-U.S. Trade Law Blog, all one word. I discovered that I've been writing about this for actually quite a while. Articles go back a year or more, particularly about solar power and electric cars. So I'll be happy to talk about those, but I thought you can read about those if you like. And I'll tell you a little bit about the case I've been doing. I just lost this case 3-3, which may sound a little strange because it is. The United States International Trade Commission is constituted by 6 commissioners. By law, by statute, they are 3 Republicans and 3 Democrats. And the Trade Commission votes. When it votes 3-3, the petitioner wins. In the last 4 years, the Commission has not voted for, that is on behalf of imports from China, ever. And indeed, I just won 2 more votes than anyone else has won in the last 4 years, but I still lost 3-3. So what is that vote about? So the trade process in the United States is broken into 2 departments of government. The Department of Commerce, which was the administering authority to which I referred, the administering authority, the Department of Commerce, does the investigation to determine whether there are indeed countervailable subsidies, whether there are subsidies being conferred under the definition you've seen, financial contribution, conferring a benefit in some form, whether there's a countervailable subsidy, and whether there's dumping, which are separate petitions but often filed simultaneously. The Commerce Department will make that determination, and if it does find that there are subsidies or dumping, it's then referred to a second agency, the United States International Trade Commission. Now, this bifurcation of the process is not common in all countries. In Australia, for example, it's one agency that does both. In Europe, it's through the same agency. The United States bifurcates the process. The United States International Trade Commission then must decide, under the mandate of the WTO, whether there's an injury caused to a domestic industry by virtue of the unfairly traded import. And it must make that determination considering whether, in fact, the industry is injured at all, and if injured, whether it's for that reason. It must distinguish whether it's the imports unfairly traded or something else that's causing the injury. If the United States International Trade Commission were to find that there were no injury or no injury caused by the unfairly traded imports, then there would be no countervailing duty or anti-dumping duty imposed. The foreign manufacturers must appear before the Department of Commerce. They have to prove their case that they're not unfairly subsidized or that they're not dumping. The importers must make their case before the International Trade Commission. They're the buyers of the goods. Now, in wind, you have essentially two parts. One part is the wind tower. The wind tower is a hunk of steel. It's made in a custom design for each turbine manufacturer, but it's nevertheless a steel fabrication. Siemens, whom I've been representing as lead counsel in this case, Siemens likes to say that they make the smart part, that's the turbine, and they buy the dumb part, that's the steel tower. In the United States, steel towers are made by a very limited number of companies. They essentially fashion steel, and they try to locate the steel production near where the tower has to be delivered, because these towers are up to now 100 meters high. They weigh thousands of tons. They're extremely difficult to move and extremely expensive to move. And essentially, they're not movable across the mountains. They're not movable often by rail, because you can't move them around corners very easily. And they're therefore roads that you can't take them on either. So the tower manufacturers in the United States located themselves in the wind corridor on the theory that they would manufacture the towers and move them close to where most of the wind farms would go. The turbine manufacturers, the ones that make the smart parts, the three leading turbine manufacturers in the United States are General Electric, Vestas, which is a Danish company, and Siemens. The turbine manufacturers can make their product pretty much anywhere, but they too don't want to have to move them very far. They're essentially making the big blades that you see as windmills, and the nacelles and all the electronics. And they're mounted on top of the towers, and the towers then are custom designed for them depending on where they're going to be located and how they're going to operate, which is also a decision of the public utility. The utility, the wind farmer, says that it will acquire a certain quantity of electricity through wind. A site is located. The contracting party is the turbine manufacturer. The turbine manufacturer is in competition. GE, Siemens, Vestas, and a number of others are competing with each other for the right to build the wind farm. Once they get that right, they need to buy wind towers. The only turbine manufacturer in the United States that makes its own towers is Vestas, with a plant in Pueblo, Colorado. All the others have to buy towers on the market. Conspicuously, the American manufacturer is encouraged to develop and very heavily subsidized through a production tax credit and investment tax credit that goes to the wind farmer. They built their tower manufacture in the wind corridor, but that also meant nowhere near a port. So as the president was encouraging them to develop for export, passage that you saw on the screen, the wind tower manufacturers never mention exports in anything they ever say, and they didn't build anywhere where they could export, because to export you need to be somewhere where you can put this tower on a boat without having to take it very far. And there were no ports. The Chinese and the Vietnamese, they built their tower manufacture right by the ports. They build the tower, they put it on a boat. For the development of wind power in the United States, the only possibility for the development in California, Oregon, state of Washington, Hawaii, Puerto Rico, ports near Texas, is through towers that are transported by boat. Because those locations are devoid of any domestic American manufacture of wind towers. All the development of wind power in the United States has taken place in those locations, have depended upon the import of towers from China and Vietnam. Some from Korea, some less from Europe. The wind tower manufacturers in the United States brought a case against the imports of towers from China and Vietnam, alleging that they were subsidized. And of course they are subsidized, just as the domestic towers are subsidized. But the towers coming in from China and Vietnam were not competing with the domestic towers. The domestic towers are all going to the heartland, to the wind corridor, close to where they're manufacturing. And they can't ship those towers to California or Oregon or Washington or Hawaii or Puerto Rico. Those towers come in by ship from China and Vietnam. So there's no direct head-to-head competition. And the domestic tower manufacturers have only been in the business since about 2007, 2008. They're new to the business. They rushed in with the introduction of the production tax credit, which made it advantageous for them as a major subsidy. They also had been often in other businesses. The largest domestic tower manufacturer in the United States, a company called Trinity in Texas, principally makes rail towers, but it could convert its factories to making wind towers. Trinity was the leader in bringing the complaint against the foreign towers. Trinity's real objective is to clear out the market, that is, to remove all competition anywhere on the continent from abroad. And Trinity is emerging as the monopolist in wind power. The production tax credit, you may know, was about to expire at the end of 2012. It was part of the fiscal cliff discussions. And as it became apparent to everyone that it was going to expire, the domestic tower manufacturers left the business. Trinity conspicuously went back to building rail cars, which, if you're an investor, you may be interested in knowing. Rail cars is a terrific business to invest in right now because we don't have pipelines to move the oil and gas from shale. It's all being moved by rail cars. So the demand for rail cars has shot up almost 50% in the United States over the last 12 to 14 months. Trinity's gone back into the business of making rail cars, not making wind towers, which it abandoned largely because the production tax credit was about to expire. So its complaint against China and Vietnam was that they were being subsidized, and it was leaving the business because it was losing its subsidy. Last week of December, the production tax credit was in fact extended a year, but it has left great uncertainty in the business. Now there are virtually no domestic towers being manufactured, and about 10 days ago, the International Trade Commission, voting 3-3, decided that duties will be imposed on the Chinese and Vietnamese towers at prohibitive rates. So there'll be no import of Chinese and Vietnamese towers, which means effectively that wind power development will stop on the West Coast, East Coast, in the port areas, on the islands. Because the turbine manufacturers are still in business. GE didn't leave the business, Siemens didn't leave the business, but they can't find towers anywhere. Because the domestic manufacturers have limited their production with the expiration, or the anticipated expiration of the production tax credit, and the Chinese and Vietnamese towers are effectively blocked from being imported into the United States. There'll be a diversion for towers from Korea. There may be more towers may come in from places like Denmark, but the cost will go up, and as the cost goes up, the price of shale gas is going down. That will make wind uncompetitive for upload to the grid. This is a story that repeats a story that we can also talk about if you like, in solar power, because it was just 2 weeks previous to the wind decision that I lost 3-3, they lost 6-0 at the commission, and now solar cells from China are effectively blocked from coming to the United States. Now the solar cells were coming in from China in great number. They were very cheap. They dropped the price of solar very substantially. The polysilicon that goes into making the solar cells came from the United States. When we initiated our case against the Chinese for the solar cells, they initiated a case against us for the polysilicon. Now the Chinese can't get the raw material and we can't get the solar cells. Now solar cells is a product that's made largely robotically, which means that there aren't a lot of jobs associated with making solar cells. But there are a lot of jobs associated with installing them. The industry that makes them brought the case, and as you saw in the statute, it identified itself as an industry, it satisfied the requirements of the petition, it brought its case, and therefore it succeeded in blocking the importation of solar cells. The several thousand jobs associated with the production of solar cells now has trumped approximately 54,000 jobs in the installation of solar cells, because our supply will now go down because the domestic manufacture of solar cells is not nearly significant enough to match the development of solar power, which was contingent upon the importation of solar cells from China. So we just repeated in wind what we had just done in solar power. And I can tell you a very similar story that had also occurred with batteries and electric cars, where China, in a retaliatory case, brought a case against American automobiles. We weren't selling any electric cars, but the petition was all about electric cars. And the Chinese have identified subsidies to companies like Tesla for $500 million to develop electric cars in the United States. As you saw in the language of the international agreements from 2009, we agreed with China that that's what we were going to do. And the trade law now makes it next to impossible. So we've seen in this sequence of cases, December 2009, the United States, in 2010, the United States brings a case against China at the WTO, initiated by the Steelworkers Union. The United States brings a case against China on solar cells in October 2011. China retaliates with a case on renewable energy from the United States at the WTO in November of 2011, and then launches its case of both dumping and countervailing duties on polysilicon. China brings a WTO petition against polysilicon from the European Union in November of 2011. In September of 2012, the European Union brings a dumping case against solar cells from China. In November of 2012, China brings a dumping and CVD case against polysilicon from the European Union. In November of 2012, the European Union brings a countervailing duty case against China, and so on. It's called a trade war. And the trade war is the inevitable product of the trade laws, making it impossible to pursue renewable energy as had been intended. As one more last little note I'll offer to you. A lot of you probably ride bicycles, so you may or may not be aware of the European case against Chinese bicycles. Over 90% of the bicycles in the United States now are made by China. In Europe, it's only about 60%. About 40% of the bicycles in Europe are still made in Europe, but they're the high-end bicycles. It's mostly a German and Italian industry. There's a lot of complaint that this is causing a problem for the development of, for the reduction of carbon emissions, because it's limiting the number of people who can ride bicycles in Europe. The price of bicycles is going up, and bicycles from China are blocked. One of the ironies is that almost all the components now made for bicycles manufactured in Europe are coming from China. But the whole bicycle can't come from China because the European bicycle manufacturers have succeeded in blocking the importation of Chinese bicycles into Europe. And this is a case that has just gone through a new round just in the last couple of months. And we'll see more of this. So it's the same part of the story, even in bicycles, where the pressure against subsidies in industries where only subsidies will make them competitive prevents development of renewable energy sources.